When we go to work, the baseline expectation is that we will return home in the exact same condition. We expect to be entirely free from work-related injuries or illnesses. That expectation breaks down into two specific categories. Safety is the prevention of immediate physical harm, like keeping a hand clear of a dangerous press. Health is the protection against disease or abnormality, shielding workers from prolonged exposure to physical agents like noise or dangerous chemicals. That these protections operate inside organizations designed to make money. A company must maintain production and generate revenue, all while navigating an intricate web of legal constraints that often conflict with the raw speed of doing business. Managing this tension relies on three unyielding drivers. There is the moral duty to prevent human suffering. There is the legal requirement to comply with statutory law. And there is the financial necessity of protecting the enterprise from the massive costs of an accident. Fulfilling those three mandates requires combating hazards across multiple disciplines. A functional workplace requires applied knowledge of safety principles, engineering constraints, occupational hygiene, and human psychology to anticipate unpredictable behavior. If leadership treats these protections as a peripheral administrative task, they miscalculate their exposure. Failing to integrate safety directly into operational strategy introduces an existential, structural risk to the company's capital. A pervasive assumption among management is that regulatory compliance is a box to check, and that if an accident does happen, the financial fallout is covered by insurance. This assumption systematically ignores the true economic impact of an incident by focusing exclusively on the most visible damages. Corporate risk models often start and end with what we call insured costs. These are the risks an organization deems sufficiently serious to transfer to a third-party underwriter. This typically covers compulsory obligations like employer's liability or worker compensation policies, along with engineering insurance to handle severe damage to plant and equipment. Relying strictly on these insured protections creates a false sense of security. It maps out a predictable boundary of exposure, assuming the worst-case scenario is simply paying a deductible. Calculating enterprise risk based solely on insurable physical damage leaves the organization entirely blind. It ignores the vast hidden network of uninsurable consequential losses that follow immediately behind any serious workplace failure. This diagram shows a cost deconstruction matrix. We can map the true financial threat of an incident by plotting direct and indirect consequences against what is insured and what is uninsured. Direct costs are the immediate, tangible consequences of an accident. When physical damage or worker injuries occur, they fit directly into this top left quadrant, usually absorbed by standard insurance policies. Beneath those immediate impacts are indirect costs. These are the less tangible, consequential losses that ripple outward from the event, making them incredibly difficult to accurately assess in the initial aftermath. On the right side of the matrix, we have uninsured costs. These are the risks the organization retains, either by deliberate financial choice or by simply overlooking a vulnerability. The real danger lies where these two categories intersect, the indirect, uninsured quadrant. This includes catastrophic variables like total business interruption, loss of production capability, and severe damage to corporate goodwill. These uninsurable consequences represent the actual financial hemorrhage of an incident. No policy covers the loss of a critical client or the operational paralysis that follows a serious injury. If a business fully tracked these hidden costs and compared them directly to the price of proactive safety measures, the justification for a rigorous health and safety budget becomes a strict financial calculation. That financial hemorrhage is compounded by the legal exposure that activates the moment an accident occurs. In the UK, a corporate failure triggers a dual-track legal system. The first track is civil law. This domain handles disputes between individuals and organizations, addressing civil wrongs, known as torts, such as negligence or a breach of the duty of care. The strict objective of civil proceedings is reparation. The courts attempt to make the injured party whole again through direct financial compensation. Calculating that compensation involves evaluating a complex set of variables. The court measures the societal value of personal loss, evaluates projected medical expenses, and projects future financial loss based on what the injured person would have earned if their capabilities hadn't been compromised. Running parallel to this is the second track, criminal law. While civil courts resolve disputes between individuals, criminal law enforces rules of behavior imposed by society for the protection of people. Criminal courts are not concerned with compensating the victim. Their sole objective is demonstrating guilt based on statutory failures and delivering punishment to the offender. A single piece of unguarded machinery or a poorly managed chemical spill triggers both the compensatory civil pathway and the punitive criminal pathway simultaneously. This diagram maps the England, Wales, and Northern Ireland court structure, showing how liabilities are processed. A civil claim ascends the left side, moving through the county court, potentially climbing toward the high court to settle disputes. Simultaneously, a criminal prosecution initiates on the right side, starting at the magistrate's court to determine statutory breaches. Depending on the harm caused, that prosecution escalates upward into the Crown Court. To determine the severity of the punishment at this level, the court applies a strict culpability matrix. This matrix assesses corporate behavior. An isolated error might be classed as low culpability. But ignoring employee concerns, failing to make changes, or flagrant disregard for standards elevates the offense straight to a very high rating. Navigating this escalating architecture requires immense capital. Defending an organization across both tracks guarantees a massive drain on operational resources and executive time, regardless of the final legal verdict. The entire weight of those uninsurable financial losses and dual-track legal proceedings returns to the integrity of those three initial pillars: moral welfare, financial protection, and legal compliance. Relying on insurance to catch the fallout of an incident is a strictly reactive strategy. It does absolutely nothing to prevent the cascade of consequences once the damage is done. The legal duty of care dictates that employers must take active measures to identify what might cause harm, executing this through systematic risk assessments. These assessments analyze human behavior, pinpointing exactly where the workforce's current actions become unsafe, and identifying where targeted behavioral interventions, specifically training, are required. That training must be deployed at specific operational trigger points, during initial employee inductions, when changing roles, or when introducing new technology. External factors force these interventions as well, requiring updated training whenever new legislation or standards are passed, or retroactively as part of a worker's rehabilitation following an illness or accident. Executing training at these precise trigger points actively disrupts the chain of events that leads directly into civil litigation and uninsurable financial loss. The modern workplace is a volatile environment where the necessity of generating revenue will constantly collide with unpredictable human behavior. Combating hazards produced by this friction requires a continuous effort spanning engineering, psychology, and legal expertise. Scattered safety directives and basic insurance cannot encompass or protect against this density of intersecting risks. A formal, rigorously implemented health and safety management system is the only viable framework capable of processing this complexity. It is the only defense strong enough to fulfill the moral duty to the worker, shield the